Be seated. Some of you may have already heard, but the new justice that has been appointed to replace Justice Grimes by the governor is Judge Barbara Pariente from the 4th District Court of Appeals. Next case on the court's calendar is a case of Time Insurance Company Incorporated versus Harvey Berger.
Please, the court. I'm Fred Lewis. I'm here this morning on behalf of Time Insurance to discuss with the court the question certified by the United States Court of Appeals concerning Florida Statute 624-155 and whether under that statute emotional distress damages can be recovered under Florida law. Here, essentially, the insurance company received a punishment in excess of $50,000 for failing to timely pay $84 in medical expenses. A little bit of the background, I think, is important to understand how this statute can operate in any given circumstance. In 1991, in March of that year, the insured had a medical procedure, sent the bill in to the insurance company. The procedure was a $500 procedure, but the bill that was actually received stated an amount of $1,500. Not coincidentally, there was a $1,000 deductible in connection with this. When the bill was received, the health insurance guide was consulted, and the bill was more than double of what that bill should have been. So the file was flagged, sent to the Special Investigations Unit, and Mr. Berger was advised, and by at least October, November, that there's a problem. There's a problem with these bills. He had counsel, and then the following February is his civil attorney sent out the 624-155 notice. That's our statutory procedure. This is a requirement that you notify the insurance company, provides a window of 60 days to either pay the amount due or to correct whatever deficiency may be involved in connection with the complaint. Here, within 46 days, the insurance company released all but the altered bill. All bills were paid with the exception of $84.18, and that was not paid until the fall of 1992. There's no evidence that anyone ever refused to treat Mr. Berger. There's no evidence that he had any other injuries over the $84 that had not been paid. Due to this inadvertence, the judgment was entered below in the federal trial court level. It is the position of Time that Florida law has never permitted the recovery of only emotional distress damages for breach of contract type actions and for the failure to pay sums of money.
So you are relying on the impact rule, is that?
There is the tort concept of impact rule is what this court has adopted as far as a tort.
But you rely entirely on that?
Oh, no, sir. I rely.
Foreseeability, and is that an issue here?
No, sir, it is not.
Foreseeability is not an issue?
No, sir. The question under the statute, it indicates whether there are certain foreseeable damages that may be recovered. Florida law has never, in connection with a breach of contract action, considered emotional distress as a foreseeable damage as a matter of law.
What would, accepting what you just said, what would this statute contemplate as damages if it did not contemplate, under some circumstances, emotional distress? What kind of damages
the courts
would it give that wasn't there before?
The courts that have considered this statute to this date have indicated that the statute made a first-party cause of action that never before existed, and that the damages recoverable would be those breach of contract types of damages that never before had been considered. The Hollier case, for example, from the 3rd District, outlined the types of damages that would be foreseeable in any other type of breach of contract action. It is not a tort action. It has been considered a breach of contract type action.
Well, how do you get anything added then if it's just breach of contract?
It creates the cause of action that did not exist for the bad faith.
Well,
you may have damages in excess of policy limits. You may have other types of damages. You may have...
I'm sorry. You're going a little too fast for me.
I'm sorry, sir.
Okay. Outline for me, what damages, new damages, if I can call it that, or other than existing breach of contract damages that the statute created. In other words, what would be the category of new damages that the statute created, whereas before in a breach of contract action or whatever wouldn't have been available.
If I may approach it
Right.
from the standpoint of, number one, the courts that have considered to this point have indicated that it didn't create new damages. It created a cause of action that had not been recognized under Florida law previously. As part of a bad faith cause of action, as going back to the early cases, going back to Baxter versus Royal
Let
Indemnity.
me ask it a different way, maybe. If your company breaches its contract
Yes, sir.
and doesn't pay, for instance, a bill, one of the things traditionally I would have thought that to be recoverable was interest.
Yes, sir.
That is, you paid the bill, it's out of your pocket or whatever, and the $500 or whatever it was due. You can add interest onto that because there was a delay in payment of that. I guess there's another statute
There may
that gives you attorney's fees.
There may be attorney's fees.
Okay, but
there may be.
what in addition to those things, which would be the general, contractual damages, what new categories what did the statute do then?
Well, that's what I was attempting to explain.
Okay.
The courts that have looked at that have indicated that 624-155, as far as first-party actions, created a cause of action that was never recognized before. That it did not create a new category of damages, it created the cause of action. You may have, under certain circumstances, damages in excess of the policy limits, for example. You may have other damage.
How would that work in a first-party claim?
How would you be able to get damages? You may have certain.
How would you, and let's take this claim, for instance. It's an unpaid medical bill. How would you get
You would not.
damages of more than the
You would not.
policy?
Under this circumstance, you would not, sir.
So what would be the damages that they would be entitled to here?
If he had,
other than contract damages?
if he had no other physical damages, he's not entitled to emotional distress damages, is the precise element that we're looking to today.
What do you mean physical damages?
There is no other physical injury caused in any fashion that's in this record.
Well, do you mean that if he was so concerned about this, if he had a heart attack, would he get damages for the heart attack?
There's no case that has ever suggested that.
But you're saying that he would?
That I think would be a different category if you're into a physical injury type of circumstance as opposed to emotional distress.
What I'm trying to do here, obviously, is give some meaning to the statute, and try to figure out in good faith what the legislature, excuse the pun, had in mind. That is, that clearly it must have been something more. As you say, if it created a whole new cause of action, usually what comes with a whole new cause of action are a whole new set of different damages. I mean, that's at least
Would be those damages.
in most tort law,
Well, you keep referring back to tort law most respectfully, and the courts of the state this court has consistently held that bad faith in the insurance context is contractual in nature.
But in trying to come to some definition of what the legislature had in mind here, that you agree that clearly they had in mind something beyond the existing contractual breach of contract damages. Do you not?
Well, sir,
Because that was already there. They didn't need to do a statute to do that, right?
But there was no bad faith cause of action. No, sir, they did need that. For first party, there was no bad faith cause of action in Florida. Until the statute.
What would be the damages in this case?
In this case, it's the $84.18 that had already been paid, plus any interest on that, and those are the only damages proved in this case. There were no other medical bills incurred because of this. There were no other claims for any other types of injuries for this. There was no other claims for anything else at all.
Well, let's slice this way. What would be the damages for bad faith?
The bad faith damages would be extra contractual damages in the nature of any expenses incurred that would be the natural and approximate result of a breach of contract action.
So foreseeability would be a factor.
As far as a breach of contract action, but Florida law, respectfully.
No, as far as the bad faith action.
Yes, sir.
Foreseeability would be an element.
Yes, sir.
Going back to Justice Shaw's question.
Yes, sir. Foresee. Do you have another question, sir?
Well, I'm trying to get straightened out here. It seemed, I would have to categorize that what the legislature did is that they created a statutory cause of action.
Yes, sir.
In fact, I think we've said that in a couple of fairly recent cases, in the Conquest case
Right.
and in the Zembrowski case.
Right, just last week or so.
Right. And that we have a statutory cause of action that has got to be dealing with some type of finite damage, or else it just wouldn't be a cause of action if it didn't create some kind of finite, or a basis to recover some finite damage.
You need elements. Agreed.
Right.
You can't leave it to a jury to
And
make
it
a
says that
decision.
you're going to recover damages. You say bad faith, but what I think we got to struggle with is that what is foreseeable if time doesn't pay these medical bills, and it has to respond to a cause of action under this statute. And why isn't the type of distress that's caused to a person in this plaintiff's position a foreseeable consequence of the failure to pay their medical bill?
The only answer that I can go to would be in those decisions of this court and for the last 20 years of Florida substantive law, and that is that it has never recognized an element of damages alone for emotional distress absent outrageous, intentional type behavior. And this court, in the McLeod decision that was rendered with regard to this specific statute, pointed out very clearly in footnote 10 that this statute did not change substantive Florida law as set forth by this court in Butchkus in 1976, that you cannot recover those types of damages in an action to recover insurance benefits.
Haven't we said that, though, in the context of there having to be some other cause of action out of which these other damages arose? That is, that if it's just a contract action, then you can't get a different category of damages. It has to be some other, and in most cases, of course, we referred to it had to be an independent tort.
Right.
And then, and then we went into,
That's right.
as you say, the intentional infliction.
Yes,
But now, as Justice Wells points out, we have this statutory cause of action, and we're trying to figure out what the legislature had in mind, as foreseeable damages for this. And of course, it's very difficult, just
Yes, sir.
the language.
Dealing with just the one element, I mean, there certainly may be a multiple types of elements that may be discussed from case to case, and certainly serious.
What would happen in a case, for instance, let's say that somebody, they had all these medical bills or whatever, and the company was in bad faith, we just did as a hypothetical here. And there were constant telephone calls, from the medical providers, and almost a harassment kind of thing. There was substantial humiliation. The person was a prominent member of the community, and the word got out that he hadn't paid his medical bills to a number of institutions, and he just was going down the tubes, and emotionally, he was, obviously we all care about our reputation and our credibility, and
Yes, sir.
and bill paying has traditionally been, a big part of that. So that person now, comes to court, and as I say, for the purposes of hypothetical, was able to establish, bad faith, and just said, I've just spent a year in hell, and then described it as I stopped going out with my friends. We didn't invite anybody over. I was depressed. Whatever. Okay.
Well,
now,
you may.
would that? Why
According
wouldn't
to these types of damages, according to the only Florida case that addressed those particular issues, Swami versus Caduceus, was a doctor in a community and got into a fight with his own insurance company about insurance policies and alleged damage to business reputation and damage to feelings and those types of things. And there, the District Court of Appeals said those are not damages.
But I'm asking you to
Yes, sir.
respond to my. You sort of say, well, gee, that makes a lot of sense. This person suffered terribly as a result of
I think
and all those things happen. Why wouldn't that be foreseeable? That is, under the language of the statute.
Because Florida law has, in the past, has made a decision that foreseeable damages from contractual disputes do not include the element of emotional distress. I think that's really the fundamental answer. You go back and look at the common law cases.
So that hypothetical
those
that I gave you
would still not qualify.
Anything, none of that suffering would be compensated for?
As Florida law stands today.
Okay.
Let me
It's
ask
almost
this.
an economic-
Before the statute,
Yes, sir.
would they have been able to recover this $84?
It had already been paid before the suit was, actually, it was filed late,
But-
so
But before the statute, would they have been able to have recovered this
Yes, sir.
$84? So what did the statute do?
the statute that this court has indicated and the others have considered it is that it has created a bad faith possibility for first-party benefits that was not recognized before, and in that bad faith would be those types of things flowing from a contractual bad faith that may be recoverable. But the legislature, in its infinite wisdom, did not go through and set forth the elements, and you certainly can't just throw it to a jury and say award whatever it is that you want to award.
What are the elements?
They have not been specifically outlined in the statute itself. I would turn back to Florida common law, with the statute being enacted with reference to the existing substantive law, to provide for those things that would flow from a breach of contract to failure to make a contract payment.
Specifically, what do you feel those are?
There would be all interest-type payments. There would be anything would flow from that breach of contract. If it's other kinds of insurances, not necessarily this case, other kinds of insurances where you sustain damages that flow from that contractual breach, you may lose other contracts, bonds, those types of things. Here, we're just dealing with the insurance payment, and those elements are not there, just a payment or indemnification for a medical bill that is already the obligation.
What about damages for the destruction of his credit rating, so to speak?
If there were any evidence of that, that may be something that could be discussed, but here we did not have any type of evidence concerning that. It was strictly the emotional distress. How were you physically during the year 1991-92 is the question. The answer was upset.
If the effect of the investigation and everything else would damage his credit rating, is that an element that you think that the statute allows for damage?
An economic damage to him very possibly would be an element of damage under the statute. However, the investigation, I would, in response to Your Honor's question, is a Florida statute that requires insurance companies to report and investigate if there is a questionable bill, a possible fraudulent occurrence. That's required by our existing statutes. I think that what we are dealing with is that here, you should also be aware that in this case, there was also a count for intentional infliction of emotional distress, the type of damages that Florida law permits, if you can prove that kind of behavior, and a summary judgment was entered on that, never tested, and that's the law of this case.
You have to agree that the statute is put there by the legislature, or would you agree? You don't have to agree to it. To give the public some relief from an insurance company that in bad faith refuses to settle and just stretches them out and hassles the injured person.
Yes, sir, I would.
Okay.
We must hope as intelligent persons that they passed it for some reason. Yes, sir.
Well, if the damages are limited and circumscribed as you have limited them here, it's almost an economic advantage to the insurance company to just not pay till the end of never, because they would never be stuck for anything other than their policy limits and these minimal
Well, no, I suggested otherwise, that there may be some in
damages
excess.
that you have mentioned, pain and suffering, credit rating, and all these big things that they're going to be hit for, that they're going to suffer rather, would not be compensable.
No, sir, if it please the court, my point today is the emotional distress element only, singularly. We do not have before us, or even in this case, any hint of economic damages of any kind, any physical personal injuries of any kind, any medical expenses of any kind.
But realistically, isn't that the big thing? If the insurance company refuses to pay and you have a serious injury and some extensive hospital bills and so forth, and the biggest thing that's going to come out of that you could be compensated for in light of this statute that you've admitted to put there to protect the public,
Yes.
is the emotional
Certainly, sir.
damage of not knowing what you're going to have, what medical expenses are going to be paid for, how you're going to pay for them, whether the company is going to approve.
If it please the court, those factors have not changed one bit over the last 20 years. And the jurisprudence of this state has
Well,
never permitted that recovery. So if you
The issue of whether or not this statute contemplated a change.
The statute does not say so, and the courts that thus far, including this court, that have considered the issue, have suggested no, it has not changed the basic substantive law as to the elements that have always been recognized as those damages. Now, if they chose to change it and spell it out and write it in some fashion, would that pass constitutional muster? Most probably, but not in this statute by saying as a matter of law in this state, the foreseeable elements of damages on a breach of contract have never been recognized by any court, as including emotional distress for the breach of contract.
Counsel, you've used up all your rebuttal
Yes.
time.
May it please the court, my name is Scott Perwin. I'm here with Brian Keefe. We represent the plaintiff and appellee, Harvey Berger. According to time, apparently, the legislature created a statutory cause of action with a higher liability standard than a breach of contract case, but no additional damages. We don't believe that was the legislature's intent.
Well, let me say that you would have to agree that historically in this state, that in a bad faith context, there has been no element of damage for mental distress, anguish, pain, and suffering connected with what we have traditionally known as a bad faith action, which has been a third party action. Wouldn't you agree with that?
Well, Your Honor, under this particular statute, which only dates from 1990, the subsection 7 dealing with damages, that particular question has not come before this court.
But put this in historical perspective. What happened prior to this statute was that this court had never recognized a first-party bad faith action. Isn't that correct? In Baxter, this court had gone with those courts which had said that in a first-party context it was a principal debtor type situation, and you couldn't be in bad faith for simply denying payment.
That's correct.
On a contract. And so what this statute as now has been construed in the Bonita Conquest case and in the other cases really has said that what this is talking about is permitting a bad faith cause of action in a first party context.
That's correct. And presumably the legislature intended to accomplish something by doing that, particularly in light of the fact that the whole purpose of bad faith doctrine is to give insurance companies an incentive to deal fairly with their insured by subjecting them to potentially extra contractual damages.
But isn't it correct that in any third-party bad faith action that's been recognized in this state, there has never been recognized a mental pain and suffering, mental anguish element? I mean, it's always been within the concept of you recover your excess judgment, and if you got an assignment, you got your attorney's fees, and really it's been focused upon the type of monetary damage that was caused to the insured by reason of the action in an economic sense.
In common law bad faith cases, that's correct. That's the Buchikas case. Buchikas case obviously predates Section 624-155 and doesn't purport to be an interpretation of it. The only case that deals even tangentially with this issue since the adoption of 624-155, and in particular subsection 7, is McLeod. And the holding of McLeod was that you couldn't get excess judgment damages in a first-party uninsured motorist case. That was the holding. That has been overturned by the legislature.
If we ruled that there could be in a first-party context a recovery for mental anguish, would we have to also, in order to be consistent, rule in a third-party context there could be?
In a statutory third-party case, I think, Your Honor, I think you would, Your Honor, because it's the same statute. That is simply a question of statutory interpretation, and the legislature in this case, in this area has made it clear that they do not like limitations on damages in statutory bad faith cases. They have gone so far in this area, as the court has recognized, as to require insurance companies to pay for damages that they didn't cause. In uninsured motorist cases, they have to pay the full amount of the plaintiff's damages, even if those damages are the result of the tortfeasor and have nothing to do with what the insurance company did. In fact, they have gone so far, it appears to us, to require the insurance company to pay for emotional distress damages that they didn't cause in uninsured motorist cases, because the total amount of the plaintiff's damages resulting from an automobile accident are going to include pain and suffering and emotional distress. So it's quite clear that since the adoption of the uninsured motorist statute, that subsection 10 of section 627.727, which was enacted after the Lafayette case, after the McLeod case, that insurance companies can be required to pay for emotional distress in first-party statutory claims, because they have to pay the full amount of the plaintiff's damages in those kinds of cases.
And the same would be true in a third-party context, as we were talking about in Zabrowski.
In a statutory third-party case, the same would be true. There is no need for this court to decide this case to decide what is the case under the common law. This is a statutory cause of action, an issue of statutory interpretation, and that's the only task before this court, is to determine the legislature.
Are you saying that this is a statutory cause of action that sounds in tort?
Your Honor, absolutely. There's no question that this is not a breach of contract case. This is a duty imposed by statute, which is a duty to act fairly and honestly toward one's insured. Acting unfairly and dishonestly toward one's insured sounds a lot to me like a tort. And clearly, under the common definition, which is in Black's Law Dictionary, it is a tort. It's because it's a private or civil wrong other than breach of contract for which the court will provide a remedy in the form of an action for damages. That's the definition of a tort. By that standard, this is clearly a tort. And in fact, the court has referred to it as a tort. In the Lafayette case written by Justice Overton, this court referred to the tort of bad faith. That's what this is. It's not a breach of contract case. It's not a duty imposed by contract law. It's not a duty to keep your promises. It's a duty to act fairly and honestly towards your insured, and that is a statutory duty sounding in tort. As we explained in our brief, there are numerous intentional torts under Florida law which carry with them liability for emotional distress, including defamation, malicious prosecution, invasion of privacy, and tortious interference. And I just want to note parenthetically, to correct something that Mr. Lewis said, the intentional infliction count that was in our complaint was not based on the same facts as the bad faith claim. It was based on the suspect bill and times initiation of criminal prosecution of Mr. Berger.
But if the legislature meant to make such a dramatic change in the common law, wouldn't you think they would have spelled it out a little clearer than they did?
Well, Your Honor, with all respect, I think it's pretty clear. To borrow a phrase that Justice Anstead used in questioning this morning, it's about as unambiguous a statute as you can get. It says the damages shall include those damages which are a reasonably foreseeable result of a specified violation of this section by the insured.
Under what the law was at that time, and the law was emotional distress alone.
Well, it may not be reasonably foreseeable in a breach of contract case, but clearly, when you're talking about bad faith by an insurance company, emotional distress is perfectly foreseeable, and all of the out-of-state cases that we cited in our brief say that it's foreseeable and that it's a perfectly appropriate element of damages in this kind of case.
I recognize that we're not addressing liability here, but what section did you sue under in order to obtain liability?
624-155-1B1, which says that the insurer has not attempted in good faith to settle claims when under all the circumstances it should and should have done so had it acted fairly and honestly toward it.
1B1?
1B1, yes, Your Honor. That's the statutory duty that's at issue in this case, which requires the insurance company to act fairly and honestly toward its insured. When the insurance company doesn't do that, when they deny valid claims without a basis, it's reasonably foreseeable that the insured will suffer emotional distress.
If that's true, then would your answer to Justice Wells be the same? Because he asked you about a third-party claim, and we've said in Zabrowski 1B1 doesn't refer to third party.
Well, I understood that case to say that it didn't apply to third-party claims when there was no excess judgment. I believe that if there is an excess judgment in a third-party claim, permissible to proceed under that statute. I may be wrong. I may be making life harder for myself than I need to. But it seemed to me that this statute doesn't distinguish between first and third-party claims. And at least with respect to statutory third-party claims, the same rules would apply. But the point is, Your Honor, if we're interpreting the statute and the statutory language which talks about reasonable foreseeability, it's clear that when an insurance company denies a claim without a basis for doing so, fails to act fairly and honestly toward its insured, the insured can suffer emotional distress. A homeowner whose house has been destroyed by a hurricane and who can't get his homeowner's insurance paid for 15 months is going to suffer emotional distress. An individual who is sick and needs medical attention, or whose child needs medical attention and is unable to get medical coverage for which the insured has paid.
Well, in the
He's going to
practical effect, though, of this going to be that any time that a health insurer denies payment of a claim, that what they're going to be confronted with is that if you don't pay the claim, then we're going to have an action under 624155 for pain and suffering.
Well, if they don't pay the claim and they don't have any basis for it and they don't respond to the notice.
You're going to have to determine whether they got a basis for it. If they breached if a jury finds that they didn't have a basis for it, that they were wrong, in although they put on 5 doctors that say that it was not pre-existing, you do, and they put on 6 that says that it was, and you get into that kind of argument,
Right.
And the insurance company loses, then they're going to be confronted with a pain and suffering claim.
If the judge allows that claim to go to the jury, that's correct. But there are the same normal judicial controls that we have in every civil case. The judge decides whether there's a jury question, whether the plaintiff has presented sufficient evidence of emotional distress, and whether to satisfy a reasonable jury, and whether the plaintiff has presented sufficient evidence that the emotional distress was the result of the insurer's conduct. And the underlying liability question, which is not simply whether there was a wrongful denial, but whether the statute was violated. That is, whether the insurer failed to act fairly and honestly toward its insured. That's a higher standard than simply saying that you were entitled to payment, you didn't get it. And also there's the additional protection of the notice. The insurer has an absolute ability to defeat a bad faith claim by paying the claims within 60 days of the notice. Time Insurance Company didn't do that. They didn't pay any of Harvey Berger's claims for 15 months, despite Mr. Lewis's statement that they released the claims. Well, they released the claims, but they didn't get paid. They didn't get paid for another 6 or 10 months after that. So clearly there was an unjustified failure to pay, and they knew by the end of August 1991 that there was no reason to deny those other claims, which amounted to a good deal more than $84. There was a deductible which reduced the amount of money that Harvey Berger received in November of '92 when the claims were finally paid.
The question that was certified was alternative. One is whether or not the statute allows emotional distress. The second one was whether, even if it does it serve as an appropriate basis for compensatory damages in this case? You didn't have any medical support for the position. The guy Mr. Berger says, I was depressed. Does that count?
He said he was a nervous wreck. He was taking medication for depression.
Should that be sufficient? Should there be a higher standard? They seem to be asking that as a second part of the question.
I think the second part of the question focuses specifically on emotional distress and whether that's a reasonably foreseeable consequence. The first part of
excuse me, that's the first part asks the question I just asked.
The first part just says, were these damages qualify as compensatory damages without trying to characterize what kind of damages they were. And in fact, they included non-emotional damages. Harvey Berger and his wife testified that he was unable to obtain medical treatment, and that his medical condition worsened as a result of that failure to obtain medical treatment.
He didn't ever testify that he couldn't obtain medical treatment.
He felt that he couldn't because he
He
couldn't
felt he
afford
could,
it.
he didn't try.
Well, Judge, he doesn't want to go to a doctor and say, I can't pay it and I don't have insurance coverage, and therefore you're going to have to treat me for nothing. I don't think that the law requires him to do that. He needed medical attention, and he didn't get it because Time Insurance Company had told him they weren't going to pay any of his claims. He didn't want to stiff a physician for a bill. And so he was unable to obtain that treatment. That clearly, in our view, qualifies as something other than emotional distress.
Well, what would be the standard by which you'd prove that the mental anguish was causally related to the failure to pay the medical bills? I mean, what
The
kind
same
of
way
evidence?
that you prove causation in any case, Your Honor, the testimony and the evidence. If the plaintiff gets on the stand and says, I was a wreck and I was perfectly fine before I had this problem with Time Insurance Company. I had to take medication, which is a verifiable fact. It was solely the result of time. I was a happy person before that. I went through a year of hell, as Justice Ansted put it. That's
enough.
presumably sufficient to go to a jury. And in fact, the quantum of proof that you need has been tested before. We cited a case from the Fifth Circuit, the Jones case, in which the very contention was that the plaintiff had to put on medical testimony to prove that he was emotionally injured in a first-party bad faith claim. The district court said, I agree, and threw it out because all he had was himself and his wife. Went to the Fifth Circuit, and they said that's enough evidence to go to create a jury question. You don't have to have medical testimony to prove emotional distress. You can prove it based on your own testimony. That's what happened here. And of course, this was a federal case, and so the same standard applies as applied in the Jones case. I just want to emphasize one other point before I sit down, and that is Time wants the court to decide whether a plaintiff in a first-party case whose only injury is emotional and who is not entitled to punitive damages can recover compensatory damages for emotional distress. That isn't this case for two reasons. One, as I've just said, Mr. Berger had non-emotional injury. Second, punitive damages were awarded. This is not the Bouchikas case, and it's not the McLeod case. There was an award of punitive damages. That was vociferously objected to by Time. The judge allowed it to go to the jury, and the jury returned a verdict in Harvey Berger's favor for punitive damages in the amount of $1. There was sufficient evidence to support that. The standard in the statute is clear. It requires proof that it's a general business practice and of reckless disregard. Both of those were clearly met in this case. There was no question about it. So Your Honors don't have to reach the particular abstract legal question that Time wants you to answer, because this is not a case in which the only damages were emotional, and it's not a case in which punitive damages.
Tell me again the non-emotional damage.
His inability to obtain needed medical treatment, Your Honor. He was unable to get treatment for his eyes, which were failing, and for which he had unsuccessful cataract surgery, and his condition worsened. It was a hardship.
Based on his testimony that he said that
He said that his condition.
I didn't want to go to the doctor because I didn't think that Time would pay it, and I didn't have any money to pay it. I mean, he didn't try. You understand that?
He was told by Time Insurance Company he wasn't going to get insurance coverage. He was not going to have any claims paid. He and his wife both testified they could not afford to obtain the necessary medical treatment, which involved going to Boston and obtaining treatment from a group of ophthalmologists there. And so he forewent that treatment, and it was a hardship on his condition. His eyes deteriorated where they would not have done so had he obtained the treatment that he was told to get. We believe that constitutes non-emotional injury. It constitutes a physical suffering on his part based on his inability to obtain the treatment.
Was there something in the evidence to show that he needed to go to Boston to see the group of ophthalmologists there?
The evidence was that that's what was recommended, that he receive treatment from that group. He testified that he had seen other ophthalmologists in town, that he had been referred to Boston, and that's where he attempted to obtain treatment. In fact, there was a $1,000 bill from that group, which was never paid by Time Insurance Company. So it's not just $84. There was a bill, and that's in the record, that was not paid. Thank you, Your Honor. Unless there are any further questions.
I think you've used up all your time. Next case on the court's calendar is the case of Benny Demps versus Richard L. Duggar.